Okay, let's just dive right into this fascinating explainer. Today, we're untangling an unprecedented, emotionally and legally complex surrogacy case that literally spans 3 different states. It's a story that starts out as a pretty common modern medical arrangement, but, well, it quickly spirals into a total jurisdictional nightmare, one that really tests the very boundaries of contract law, bodily autonomy, and parental rights.
To really wrap our heads around this today, we have to look at a real-life standoff that challenges absolutely everything we thought we knew about legally binding contracts. So ask yourself, when a surrogate is carrying a child for biological parents, who actually gets the final say over the pregnancy when unexpected tragic medical realities pop up?
Here's our roadmap for today's explainer. We'll be covering 1. The surrogacy contract. 2. A sudden medical diagnosis. 3. Fleeing across state lines. 4. The 3-way custody battle. And finally, 5. The broader implications for surrogacy agreements.
Section 1. The surrogacy contract, establishing the initial agreement. Let's see exactly how this story builds, from what started as a standard agreement of trust.
The whole foundation of this situation is an agreement signed in California between a California-based couple, the biological parents, and McKenna West, a surrogate living all the way up in Alaska. You know, on the surface, this is a super standard process. These surrogacy contracts are meticulously drafted to anticipate complications and establish absolute legal boundaries for the 9 months ahead.
But here is the crucial detail. This specific California contract explicitly included a medical termination clause. And in California, these types of specific clauses are entirely 100% legally enforceable. So, by signing this document, both parties legally establish the biological parents as the ultimate decision-makers if, heaven forbid, a severe health crisis arose during the pregnancy. California's jurisdiction was really meant to be the legal anchor for the whole shebang.
Moving on to Section 2, a sudden medical diagnosis, the inciting incident. Halfway through the pregnancy, the predictability of this contract was put to the ultimate test.
Right around the 20-week mark, an ultrasound revealed a significant heart defect in the baby. It was a really severe condition, one that would require at least 3 intensive surgeries right after birth. Faced with this incredibly daunting medical reality, the biological parents made a truly agonizing choice. They decided to actually exercise their legally protected contractual option for termination to prevent the child from undergoing immense medical suffering.
So McKenna initially scheduled the procedure for the 22nd week mark, but then a massive emotional shift occurred just days before the appointment. She was really grappling with the profound physical reality of carrying this child, and this led to a sudden, complete reversal of the agreed-upon plan by May 4th.
On May 4th, McKenna sent this powerful message to the clinic. She wrote, "After careful thought, I've decided that I cannot terminate this pregnancy. This baby is in my body, and I care for him very much." She went on to express that she was sharing hormones, vitamins, and food with him, and, well, she had just become closely connected. The physical sensation of life had completely overwritten the legal document she'd originally signed.
Which brings us to Section 3, fleeing across state lines, the jurisdictional nightmare, because McKenna's sudden decision immediately created a literal, multi-state legal crisis.
To avoid California's laws, McKenna strategically fled to Texas. And why Texas? Well, because in Texas, termination clauses within surrogacy contracts will absolutely not be enforced. No way. She actively sought out a geography where state law would shield her emotional decision and completely overwrite the California contract. It's a really profound example of how just crossing a state border can totally flip the legal reality of an agreement upside down.
The moment the baby was successfully delivered in Texas, the fundamental legal power completely shifted. Overnight, this case transformed from a simple breach of contract into a highly complex geographic turf war. The infant was now physically located in a state with vastly different views on the rights of a surrogate versus the enforceability of that original California contract.
Section 4. The 3-way custody battle, a legal standoff. This brings us to the climax of the story, an unprecedented legal gridlock involving 3 very distinct parties.
So, we now have 3 distinct parties, each claiming legal authority over the newborn. First, you have the biological parents fighting in California for their constitutional rights to their genetic child. Then you have McKenna in Texas, fighting for full custody based on her physical and maternal connection. And finally, stepping in as a surprise third party is the Texas Attorney General, Ken Paxton, fighting to maintain state medical oversight right there within Texas borders. Now, looking at McKenna's current legal standing reveals a pretty massive paradox. She's seeking full custody in Texas based on carrying the child to term. Yet, she is currently under a strict restraining order. She literally cannot legally go anywhere near the newborn infant she just delivered.
On the flip side, some concerns were raised about the biological parents' intentions, since they had originally opted for termination. However, they strongly deny any claims of withholding medical care. Their legal argument is actually very straightforward. They want to take full legal possession of their child, assess his health, and bring him back to California for those necessary intensive follow-up surgeries.
Meanwhile, Texas Attorney General Ken Paxton secured a legal order keeping the baby in Texas for immediate medical care. The biological parents are, as you might guess, pushing back incredibly hard against this. They argue it's a massive, unconstitutional overreach. They state the Attorney General has absolutely no standing to dictate the medical care of their embryo, arguing this should be a standard family services issue, definitely not a matter for the state's highest legal office to interject into.
Section 5. Implications for surrogacy agreements, the broader impact. Let's zoom out for a second and consider why all of this matters so much for the future of reproductive law.
Surrogacy contracts have actually been a legally established standard practice since the 1980s. People have relied on their enforceability for decades now. But this single case in 2024 has severely tested the boundaries of interstate enforcement. It's exposed these massive loopholes that appear when the laws of two distinct states wildly diverge.
This case objectively highlights the incredibly messy reality of what happens when raw human emotion directly collides with a legally binding interstate contract. For anyone considering IVF or family planning across state lines, it raises a really massive question. What good is an intricately drafted agreement if simply crossing a state border can nullify it entirely?
I'll leave you with this provocative thought. As medicine continues to advance and people increasingly cross state lines to leverage different legal systems, are our state laws truly prepared for interstate disputes like this one? It's a profound legal frontier, and one that could permanently reshape how we define enforceable contracts, jurisdiction, and family planning moving forward.